I have watched appellate rulings dismantle regulatory frameworks before, not through incremental adjustments, through comprehensive analysis that identifies a constitutional defect so fundamental that entire categories of regulation collapse simultaneously. And when that collapse occurs at the circuit level, it creates a legal asymmetry where rights depend on geography, where identical conduct is protected in one state and criminal in the next, and where the instability itself becomes the argument for Supreme Court intervention. In February 2026, the United States Court of Appeals for the Fourth Circuit issued a decision in Maryland Shall Issue v. Moore that struck down 10 distinct categories of firearm regulations enforced across Maryland, Delaware, Virginia, West Virginia, North Carolina, and South Carolina. The consolidated case involved challenges to multiple state laws, and the Fourth Circuit conducted comprehensive historical analysis under the Bruin framework and concluded that none of the challenged regulations had sufficient historical precedent to survive constitutional scrutiny. The decision was 187 pages, authored by a 3-judge panel. The ruling was not unanimous. Judge Richardson wrote a 73-page dissent, arguing that the majority applied the historical tradition test too rigidly. But the majority opinion is now binding precedent throughout the Fourth Circuit, governing federal district courts in Maryland, Virginia, West Virginia, North Carolina, and South Carolina. Approximately 38 million residents now live under a legal framework where regulations, enforceable in January 2026, became constitutionally prohibited in February. The first category struck down was magazine capacity limits. Maryland and Virginia both restricted magazines to 10 rounds. The Fourth Circuit held that standard capacity magazines are arms in common use, with over 100 million in civilian possession. The court found no historical tradition of restricting capacity during the founding era or Reconstruction. Colonial militias used firearms with whatever capacity the weapons possessed. The second category was assault weapon bans. Maryland prohibited semi-automatic rifles with features including pistol grips, folding stocks, and threaded barrels. The Fourth Circuit applied the common use test and found that AR-15 platform rifles are the most popular rifles in America, with over 24 million in civilian hands. The court held that features like pistol grips are ergonomic characteristics that do not make a firearm more dangerous in any legally meaningful sense. The third category involved waiting periods. Several states imposed mandatory delays between purchase and possession, typically 3 to 10 days. The Fourth Circuit found no historical precedent for waiting periods. For most of American history, purchases were completed immediately. The fourth category concerned expansive gun-free zones. Maryland and Virginia had designated broad categories of locations as sensitive places where firearms were prohibited. The Fourth Circuit held that historical tradition supports narrow, specific location-based restrictions, but does not authorize blanket prohibitions that effectively nullify the right to bear arms in public. The fifth category was permit-to-purchase requirements. Maryland required individuals to obtain a handgun qualification license before purchasing any handgun. The process took 30 to 90 days. The Fourth Circuit held that while background checks at point of sale are consistent with historical tradition, requiring a separate license before being allowed to purchase has no historical precedent. The sixth category involved may-issue concealed carry systems. Maryland had attempted to maintain discretionary elements by requiring applicants to demonstrate good and substantial reason. The Fourth Circuit held that this requirement still vests licensing officials with discretion to determine whether an applicant's stated reason is sufficient. The seventh category concerned state-level dealer licensing beyond federal requirements. The Fourth Circuit held that imposing separate state licensing schemes for conduct already regulated by federal law creates barriers to commerce that indirectly burden Second Amendment rights without historical justification. The eighth category was ammunition purchase restrictions. The Fourth Circuit found no historical tradition of regulating ammunition separately from firearms. The court held that ammunition is essential to firearm function, and that restrictions on ammunition access indirectly restrict the right to keep and bear arms. The ninth category involves certain applications of red flag laws. The Fourth Circuit did not strike down extreme risk protection orders entirely, but it held that orders issued ex parte without the gun owner present and extended beyond brief emergency periods without full adversarial hearings violate due process. The 10th category was mandatory registration systems. The Fourth Circuit held that while point-of-sale background checks serve legitimate purposes, ongoing registration requirements, creating permanent government databases tracking lawful ownership, have no historical precedent. The cumulative effect is the wholesale restructuring of firearm regulation across the Fourth Circuit. Maryland lost the majority of its regulatory framework. The decision does not create legal obligations in other circuits, but it creates a stark circuit split. The Ninth Circuit has upheld magazine capacity limits and assault weapon bans. The Second Circuit has upheld similar laws. The Seventh Circuit has upheld assault weapon bans, using reasoning the Fourth Circuit explicitly rejected. This is exactly the kind of circuit split that compels Supreme Court intervention. The Fourth Circuit's decision makes Supreme Court review nearly inevitable. Multiple states will petition for certiorari. Gun rights organizations will file their own petitions. The case will almost certainly be before the Supreme Court by the 2026 term, with a decision by June 2027. But until the Supreme Court acts, the Fourth Circuit's decision creates legal chaos. Maryland's Attorney General announced the state would seek en banc review. Meanwhile, enforcement has effectively ceased for the struck-down regulations. Maryland cannot enforce its magazine capacity limit, assault weapon ban, waiting period, or permit to purchase requirement. State officials have issued guidance directing law enforcement not to arrest or prosecute for violations of invalidated laws. This creates danger for gun owners. The Fourth Circuit declared these laws unconstitutional, but until Maryland formally repeals them, or the Supreme Court affirms, the statutes remain on the books. A gun owner possessing a standard capacity magazine in Maryland is technically violating state law, even though the Fourth Circuit held that law is unconstitutional. The patchwork becomes even more complex at state borders. A Virginia resident can now legally possess an AR-15 with a 30-round magazine because Virginia falls within the Fourth Circuit. If they cross into West Virginia, also in the Fourth Circuit, they remain legal. But cross into Pennsylvania, which is in the Third Circuit where the Fourth Circuit decision does not apply, and they may be violating Pennsylvania law. Geography determines legality, and the Fourth Circuit decision has redrawn the map. Gun rights organizations are already planning litigation strategies to extend the Fourth Circuit's reasoning to other jurisdictions. Cases are being filed in the Ninth Circuit challenging California's laws, using the Fourth Circuit decision as persuasive authority. Similar cases are being prepared in the Second Circuit, targeting New York and Connecticut. The goal is to create multiple circuit splits that all point in the same direction, making it impossible for the Supreme Court to avoid granting certiorari. Gun control organizations are equally focused on limiting the damage. They are filing amicus briefs in pending cases urging other circuits not to follow the Fourth Circuit's reasoning. They are arguing that the Fourth Circuit misapplied the historical tradition test, relied on incomplete historical evidence, and failed to give adequate weight to government interests in public safety. They are preparing their own Supreme Court strategy, anticipating that when the court grants certiorari, the battle will be over which circuits approach the court endorses. Gun rights organizations are already planning litigation strategies to extend the Fourth Circuit's reasoning to other jurisdictions. Cases are being filed in the Ninth Circuit challenging California's laws, using the Fourth Circuit decision as persuasive authority. Similar cases are being prepared in the Second Circuit targeting New York and Connecticut. The goal is to create multiple circuit splits that all point in the same direction, making it impossible for the Supreme Court to avoid granting certiorari and resolving the underlying legal questions. Gun control organizations are equally focused on limiting the damage. They are filing amicus briefs in pending cases urging other circuits not to follow the Fourth Circuit's reasoning. They are arguing that the Fourth Circuit misapplied the historical tradition test, relied on incomplete historical evidence, and failed to give adequate weight to government interests in public safety. They are preparing their own Supreme Court strategy, anticipating that when the court grants certiorari, the battle will be over which circuits approach the court endorses. What makes the Fourth Circuit decision particularly significant is its comprehensive scope. Previous Second Amendment decisions from appellate courts have typically addressed one or two categories of regulation in a single case. A court might strike down a magazine capacity limit or uphold an assault weapon ban. The Fourth Circuit addressed 10 distinct regulatory categories in one consolidated proceeding and struck down all of them using the same historical analysis. That creates a template that other courts can follow and establishes a methodology for evaluating firearm regulations that strongly favors constitutional challenges. The decision also demonstrates how the historical tradition test functions as a one-way ratchet. Once a court determines that no historical precedent exists for a particular type of regulation, defending that regulation becomes nearly impossible. States cannot create historical evidence. They can only point to what existed. And when the founding era and Reconstruction period produced no laws limiting magazine capacity, imposing waiting periods, or requiring registration, modern legislatures cannot overcome that absence through policy arguments about effectiveness or necessity. For gun owners in the Fourth Circuit, the immediate practical effect is substantial. Millions of firearms and accessories that were prohibited in January became legal in February. Standard capacity magazines that Maryland residents could not legally possess are now constitutionally protected. AR-15 rifles that were classified as assault weapons are now recognized as common arms. The waiting period that delayed purchases no longer applies. The permit to purchase requirement that added months to the acquisition process has been eliminated. The decision also demonstrates how the historical tradition test functions as a one-way ratchet. Once a court determines that no historical precedent exists for a particular type of regulation, defending that regulation becomes nearly impossible. States cannot create historical evidence. They can only point to what existed. And when the founding era and Reconstruction period produced no laws limiting magazine capacity, imposing waiting periods, or requiring registration, modern legislatures cannot overcome that absence through policy arguments about effectiveness or necessity. I have watched regulatory frameworks collapse under the weight of historical analysis before, not through dramatic confrontation between branches of government, through the methodical application of a constitutional test that treats the absence of historical precedent as dispositive. The Fourth Circuit did not declare that gun control is bad policy. It did not weigh costs and benefits. It asked whether each category of regulation had roots in founding era or Reconstruction era practice. And when the answer was no, the regulations fell. The trajectory is clear. The Fourth Circuit's decision will either be affirmed by the Supreme Court, extended to other circuits through additional litigation, or reversed through en banc review or Supreme Court intervention. If affirmed, the majority of gun control regulations enacted over the past 30 years become constitutionally suspect. If reversed, the circuit split deepens and the legal landscape fragments further. Either way, the next 18 months will determine whether the Second Amendment framework established in Heller and refined in Bruin results in uniform national standards, or permanent geographic division, where constitutional rights depend on which circuit you live in. The Fourth Circuit struck down 10 categories of gun laws, but the number matters less than the reasoning. The court established that historical tradition is not merely a factor to consider. It is the only factor that matters. And when that standard applies rigorously, most modern gun control laws have no defense.